Hello, everyone. Thank you for tuning in. The Cincinnati Bar Association is pleased to present a series of public information sessions answering common questions about legal issues in the wake of COVID-19. Today's session will focus on probate and estate planning. Kara and Scott, welcome. Kara Lyons is an attorney with Lyons & Lyons Law, and Scott Hoberg is a partner at Hoberg. Thank you both for your time and expertise. If you need legal assistance, please go to cincybar.org/LRS for our lawyer referral service. Questions answered are not to be considered specific legal advice and are meant to address general areas of interest regarding these issues as they relate to the COVID-19 pandemic. Welcome, both of you. How are you?
Hey, thanks
for having us. Doing well, thank you.
Thank you. Thanks for being here. So we're just going to get started reading off some of the questions. The first one I'm going to toss to Kara to start us off. Scott, if you would like to join in, that would be awesome. First question. My spouse is in the hospital and we don't have a will. How do we get one?
First, you should probably contact an attorney. Many attorneys are doing phone consultations or video consultations where they can gather information needed to draft your will. The problem right now with being in the hospital is having the witnesses involved. So a lot of times, the will has to be witnessed by two uninterested parties. Hopefully the hospitals are willing, the nurses or staff are willing to witness the will. Because the attorney can prepare it for you, send it to either the spouse or the person in the hospital to review. And as long as they have it there, like I said, it can be witnessed or signed and then witnessed by the two uninterested witnesses, and it's official.
Scott, did you have anything to add?
Nothing too much. Just it's important to take into account when it comes to wills. Each person has their own will. So even if your spouse isn't able to get one, or you're not able to get the logistics done when it comes to your spouse, if you are somebody that's still able to be ambulatory, being able to move around freely, being able to go ahead and get those two disinterested people to sign your will, then certainly you should go ahead and take those steps as well. I know as Kara pointed out, we're doing meetings, we're meeting people where they are, which is oftentimes on Zoom, oftentimes on FaceTime, or just a standard phone call, depending on what people are comfortable with. Law firms are, as of right now, they are essential businesses. You still have the option to meet with attorneys in his or her offices, if that's something that everybody is willing to do. And if that's the case, then hopefully those law firms are taking the necessary safety precautions to ensure that everybody is maintaining the safe distancing, making sure everybody is, going forward and making sure that everything's a clean and as comfortable environment as possible.
Great. Okay, Scott, I'm gonna give you the next question. Mm-hmm. Someone in my family has passed away. What are my next steps? It's a pretty broad question, but.
Right. And, there are a number of things to take into account, just not even thinking as a lawyer, just as a person. If we have family members and loved ones that have passed away, there are a number of steps that you have to take. The first thing that you want to do is just make sure that the steps are taken to ensure that the funeral goes off without a hitch, or the way that that loved one has planned it. Hopefully that loved one has pre-planned their funeral. Hopefully those logistics are already in play. And if so, then there won't be that many decisions that need to be made. Sometimes those desires, sometimes those wishes are articulated or are written down in somebody's will or is with their estate planning paperwork. If that's the case, it's important to make sure that those things are actually followed through with. Another thing to take into account when you go to the funeral home is make sure that you have a death certificate for your loved one. Hopefully try to get a number of certified copies. That's going to make the life for whomever is going a little bit easier over the next couple of months when it comes to going through the probate process. Probate is sometimes the next step after the funeral. after what happens when all the loved ones, bid their goodbyes. It's essentially what is done in order to make sure that the person that has passed away is able to divide up what they want to divide up and give away what they have desired to give away. Hopefully they have an estate plan, as we said before, that says where things are supposed to go when somebody passes away. But even if they don't, there are a set of rules that Ohio law has already written to say where things go. And oftentimes that still involves going through the probate process. If you have if the one that has passed away has a spouse, oftentimes there probably isn't a whole lot of steps that need to go or that need to be accomplished through probate. But if this is the second spouse to pass away, if somebody has passed away unmarried, then oftentimes in those circumstances, that's probably where you're going to see more and more of participation in what's called a probating of somebody's estate.
Okay, thank you. Kara, this next one is for you. Someone in my household is considered at high risk for COVID-19 and can't leave the house, but needs to renew the registration or license. What do I do?
Well, first, don't worry. The state took that into account when they started putting these emergency orders in place. So first with the license. Currently, Governor DeWine has signed a bill which states that Ohio licenses expiring during this declared state of emergency will remain valid until either 90 days after the declared emergency ends or until December 1st, 2020, whichever occurs first. And then during this time, the BMV is pausing any suspension for failure to pay or renew a license. So it's kind of, like I said, it's already accounted for. Don't worry, there will be time to get that taken care of. As far as the registration goes, a couple options. If you recently purchased a vehicle, if you purchased it at a dealership, most of the dealerships will have the ability to get you a temporary tag. If the dealership does not sell temporary tags, or if you bought the vehicle through a casual connection, if you bought just from a normal person, you can always get get your temporary tags online through the BMV's website. And then if you need to renew your registration, you can always do that online as well or by mail. So just go to the bmv.ohio.gov.
Okay. Pretty cut and dry.
Yeah, that was an easy one.
Yeah, good. Scott, this one might be a little harder then, but the next question is for you. What is power of attorney? What does that mean for someone?
A power of attorney is a legal document that allows you to name somebody that you know and you trust to make decisions for you in a certain event. Now, in Ohio, there are really two types of powers of attorney. The first type is financial power of attorney, and that's a document that allows you to name somebody that you trust. Oftentimes, it is a spouse to make financial decisions for you and for your finances, whether you're talking about bank accounts or checking accounts to things such as trusts or things you may not necessarily think of, but can actually come into a lot of value in a pinch, like real estate. If you have a spouse that travels a lot, having that spouse giving you a power of attorney can make things go a little bit easier if you have to do what's called a round table closing for real estate. That's a financial power of attorney. The second type of power of attorney, and it's the one that you generally hear of when you check into a doctor's office, is what's called a healthcare power of attorney. In that same vein as a financial power of attorney, you're naming somebody that you trust to make decisions for you in the event that you are not able to speak up for yourself. You don't necessarily have to be incapacitated. You can actually go ahead and give a power of attorney certain rules to follow in terms of what you're cool with them doing and what you're not cool with them doing. And what that can do is allow you, as I said before, to speak up for yourself when you're not physically able to do so, and name somebody that you trust that can follow through with what you want to have done, to have them go ahead and make those decisions for you when the time arises.
Okay. Kara, next question is for you. What do I do if someone or myself in my house, someone in my house or myself is ill with COVID-19, but we need to make a court appearance?
Okay. First, if you have an attorney, contact that attorney. Let them know that you're ill or that someone in your house is ill and you aren't able to attend. The attorney can act on your behalf and can either request a continuance from the court, which would then move the date of the appearance a little bit down the line, or they can, a lot of times the attorney can appear on behalf of the client without the client being present. Currently too, a lot of the courts are utilizing telecommunications in lieu of personal appearance. So a lot of them are doing either phone status conferences or they're using Zoom technologies or WebEx technologies to have these hearings remotely. If you don't have an attorney, contact the court and just let them know the situation.
Okay. Scott, next one is for you. And I guess that kind of coincides with that one actually. Is there a difference between someone witnessing my will in person as opposed to virtually?
Yes, and the reason why is that really, as of right now, we don't have a clear guide work or any real framework on how somebody can witness a will remotely. However, there are some other estate planning documents, like powers of attorney, that can be notarized remotely. The state of Ohio, over the past year or so, has implemented some steps that can be taken in order to notarize or to have what are called remote notaries, and there are a set number of guidelines that they need to follow. There's a set procedure in terms of even being a remote notary, which is on top of what is normally required for notaries public. However, that still has yet to kind of cross over into having witnesses being able to witness wills. So you can't have your will notarized. It needs to be witnessed, as Kara indicated earlier. And so because of that, there really isn't any way at this point with any real clarity to be able to do it. Now, chances are, if we really do run into a situation where there are a lot of problems, I'm sure there's going to be some sort of workaround that may be provided. You know, Ohio still has some case law that can kind of take care of what are called holographic wills, or things that may not necessarily comport to all four corners of a standard will or estate plan. But that being said, you're better safe than sorry. Look, the reason why people have estate plans is to formally be able to say where things go when the situation arises, and you don't want to create something defective with the purpose of having it not accomplish what you want to have accomplished.
It kind of aligns with the next question, which was, can I have my will notarized by the public notary at the bank? And the answer is no. I mean, you can, but the legally binding is through an attorney.
Now, that being said, that notary at that bank could still act as a witness. You know, as long as they're there in person, they can act as a witness. So they don't necessarily have to have their notary public hat on. They can just be, a standard witness that can notarize or that can witness the will. I will add that it is important to contact your bank ahead of time to see if they will even act as that. I know it sounds kind of counterintuitive, but there are a number of larger financial institutions in this town that have kind of curtailed, for some reason or another, their roles as notaries public, and they may not necessarily be willing to completely notarize even financial instruments or estate planning instruments for their own customers, even if you have accounts open. So that's something to always call ahead of time and clarify before you make a trip out there too.
Interesting. Okay.
Kind of one more thing just to add about the witnesses. The witnesses do have to be in the conscious presence of the signer of the will, which is called the testator. So that you can sign a will and have to go to two different people down the street and have them sign it. They both have to be there when you're signing it, and they have to be in the presence of each other.
Yeah.
Very interesting. I'm glad we're doing this session. Kara, then we'll pass the next question to you. A relative unexpectedly passed away from COVID-19 and did not have a will. What do I do?
First, again, contact an attorney, preferably an attorney who specializes or who deals with probate estates. If you don't know one, definitely contact the Cincinnati Bar, because they do have a program where they can put you in contact with a couple of attorneys who would be able to handle you with that matter. Then next is to determine who has the right to administer the estate. So normally, if you have a will, you have a named executor, and that's going to be the first person in line to handle the administration. However, if you don't have a will, then it has to go based on statute and who's entitled to handle the estate. So if you're married, the first person is the surviving spouse, or then it goes no surviving spouse, or if the surviving spouse can't serve or doesn't want to serve, then it goes down to the next of kin, which would be any next relatives, so children first, and then down the line that way. One caveat though is that if you don't have a will, the administrator has to be an Ohio resident. So that kind of can add some issues some places if you live in Ohio, but all your family lives in Kentucky. It's going to be a little bit more hoops to jump through to figure out who's going to handle this estate. And then from there, it's kind of the same process as if you did have a will. You want to make sure you want to determine who is going to serve as that administrator or who's going to apply to serve as that administrator. Determining what are the assets that do need to transfer through the probate process. And in doing so, you can also determine what type of probate. So Ohio recognizes 3 different types of probate administrations. They're all based upon who are the beneficiaries and the dollar value of the assets. So there is a full administration, which would be kind of the most normal, what you hear most of the time. There's a relief from administration, which is a little bit of a quicker process. And again, depends on the dollar value and who is the ultimate beneficiary. And then there is a summary release from administration, which essentially is just used to make sure that whoever paid for the funeral is paid back. So depending on what the assets are, you can determine what level of probate you need to open. And then working with an attorney to make sure you get the right authority to handle those assets and get things transferred based on the statutes. So again, if you don't have a will, there is already a set way of where your assets will go, depending on your marital status and the children.
Okay. Fantastic. Let's see. Scott, next one is for you. What is the difference between a will and a living will, and trust and a living trust?
Okay, so I'll start with the difference between a will and a living will. Essentially, a will is a document that tells where things are supposed to go when you pass away, specifically property, as well as it gives you the ability to name guardians for your children if something were to happen to you. So you can nominate somebody to who will hopefully parent your child if you were to pass away from from the point of you passing away until they turn 18 or graduate from high school, whichever occurs later. That's basically what a will is. A living will is actually sometimes referred to as a last care directive. It's a document that actually functions a little bit, it's a little closer to a healthcare power of attorney than it actually is to a last will and testament, because it takes into account what sort of palliative care, what sort of comfort care, what sort of life-sustaining treatment you want to have accomplished if you happen to find yourself in a situation where you're not able to speak for yourself, and those individuals caring for you have to make those decisions about what sort of treatment you're supposed to get. It's an important document to have, not just because it allows you to make sure that your desires are respected by those who are going to be making those decisions for you. It's also important because you don't want to saddle your family members with them trying to think what it is that you actually want to have done. You don't want them to armchair quarterback what Scott would have liked to have done when it comes to hydration or intubation or things such as that. You don't want to pressure people into making those decisions. It gives you an opportunity to speak up for yourself, have your desires taken care of, and that can put a lot of family members at ease as well. Now, a trust and a living trust, just to answer that question. A living trust is a type of trust, and specifically, it's a trust that you are able to, that you create while you're still alive, and it is not something that really takes effect until after you die. It's something that's kind of able to be amended. It's able to be changed. It's able to be funded specifically while you're still alive. And the fact that you fund it while you're still alive is what makes it a living trust, as opposed to what's called a testamentary trust, which is what is set up to act as a trust after you pass away.
I see. Kara?
Yeah, just a couple things to add to it. The living will, what a lot of people hear it is as the pull the plug document.
Yeah.
So it's like you said, it's the advance directive. It's you making the decision now while you're healthy as to what you would want to happen if you were ever in a terminal condition or permanently unconscious state and only being kept alive by artificial means. So again, if you want the plug pulled, you can say it now while you're healthy so that nobody else has to make that decision for you.
Okay, thank you. I think the last question kind of touches back on everything. I know what Kara's going to say is the first answer, but this one is for you. My spouse and I have not done any estate planning, and COVID-19 worries are making us interested in starting. What are the basics we can do now?
Contact an attorney. But truly contact an attorney. I know a lot of times people think, oh, they're just really easy documents. I can just do it myself. There are specific things in the law that there are formalities that need to be followed to make them effective. So it's not something you want just to have a very basic document you pull off the internet. You want to make sure that you have an attorney who's pulling your records, making sure that things are titled correctly, that kind of goes over and explains to you what would happen if one spouse were to pass, or if you were to pass away, giving you a good overview of what to expect and what to take care of. But right now it's nice because law offices have been deemed essential businesses. So most are open and ready for appointments. Again, I know it's people wanting to maintain the social distance. I know a lot of offices are putting up, having the availability of being able to meet remotely, again, either via Zoom or on the telephone consultation. But there are 4 basic documents that everybody should have. And then your attorney can kind of determine if you need to build on that. So the 4 basics are the will, the healthcare power of attorney, the living will, and the durable power of attorney for finances. And then again, based on your personal situation, your goals, objectives, your family situation, the attorney can help assist in drafting a plan that makes sense for you, that's going to accomplish what you want to accomplish.
Okay. I have to ask you guys while we're on here then. So, a lot of people might think that if they write something down at home that, just like in passing, if they're thinking about it before they can have any kind of, legal aspect stamped on it, that's something that can live beyond them if they were to, unexpectedly pass away. Is there any kind of legal precedent for that? Like if I was to write something on a napkin or on a piece of paper and, sign it on and date it, does that carry any power later, or,
That's what the witnesses come in. It's hard because when you bring something into the probate court and the court's trying to determine whether this was something you did, when you don't have the witnesses there, there's no proof that that was actually you who wrote that or who signed that or who did that. So the court doesn't really want to give too much credence to documents like that. I think Scott had mentioned earlier, there is some case law that's able to get some of these things in if need be, but that's going to be more court work, more expense, having attorneys coming in and verifying it, having hearings, having trials, determining what these documents are and what power they're going to hold.
Okay. Well, we've reached the end of our questions. Is there anything that we didn't cover that you think that, that you wanted to cover? Okay.
Well, I would be remiss if I didn't, take a moment to say that hopefully everybody is safe out there. Hopefully everybody is being able to take care of themselves and their loved ones during this time. When it comes to estate planning, a lot of it is about starting to have a conversation with your loved ones, wanting to make sure that your desires are being taken care of. And you don't necessarily have to have an attorney to begin that conversation with your spouse, with your children, with your family. Getting them to kind of get in the framework and the mindset to begin to take these to go on this decision-making process can go a long way when you're sitting down with an attorney. If you're somebody that hasn't sat down with an attorney before, don't worry about it. We don't bite. certainly, you know, I often send my clients a big questionnaire of things to fill out. Some of the stuff is germane to their situation. Some of it isn't. I don't expect a lot of my clients to have mineral rights, for example, but I've run into situations before where I have to ask that. But really what we want to do is make sure that families are discussing what their desires are, then hopefully being able to take action on it. And at that point, being able to get these decisions that they want to have made down on paper and have it protected, so that in the event of you know, unforeseen circumstances or even foreseen circumstances, their desires are able to be followed.
Yeah.
Wonderful.
I think another thing too to think about is, I get asked a lot, when do I need these estate planning documents? Like, well, I don't have anything. Do I necessarily need a will?
Mm-hmm.
And you probably have more than you think that you have. You might not think you have a lot, but you have things to make provisions about, especially if you have children. If you have children involved, you definitely want to make sure you have a guardianship nomination. You have a plan in place that if something happened to you, that who's going to take care of my kids? Who's going to make sure that they have money for education, that they have everything they need to succeed in life, as if I were there. Another thing too is, if you have kids who are over 18, things you need to think about is having a healthcare power of attorney and a financial power of attorney for them. If your kid's off in college, you think automatically, oh, that's my kid, they're on my insurance. I can, if they're in the hospital, I'm going to be able to access those things. The HIPAA privacy laws have made it really difficult. So hospitals cannot disclose information about you unless you have authorized them to do so. So even though your 18-year-old freshman in college is on your insurance, it doesn't matter. They are 18, they are legally an adult. So if they're in the hospital, unconscious for any reason, or unable to make these decisions, you're a lot of times going to be stuck in the waiting room with the hospitals not able to give you the information that you're probably wanting to know and wanting to be able to make those decisions for them. So making sure that they have documents, especially before going off to college, is so important.
Absolutely. Okay. Thank you both so much for answering some of these questions. Or rather, you answered them all, but thank you for answering a few questions that we selected. I think that we started on Facebook Live a few minutes late, so I just wanted to let anyone who's watching know that these questions answered are not to be considered specific legal advice. They're meant to address general areas of interest regarding these issues as they relate to the COVID-19 pandemic. Our panelists today have been Kara Lyons, an attorney with Lyons & Lyons Law, and Scott Hoberg, a partner at Dever Hoberg. If you need legal assistance, please go to cincybar.org/LRS for our lawyer referral service, and we can go from there. So thank you both so much. I really appreciate it.
Thank you.
Be well. Take care.
You too.
Bye.
You too. Bye.